Hi, my name is Adam Rosenblum, and I'm a copyright infringement attorney. Today we're going to talk about unauthorized use of copyrighted material on the web. We often get contacted by artists, medical illustrators, or photographers who have discovered that their works appear on other people's websites who have not paid for a license. Contrary to popular belief, just because you can right-click and save an image very easily, that doesn't mean that it's legal. To the contrary, once a work is copyrighted, the burden is on the person who's using the image to determine in advance whether or not they have the rights to use the image. That might sound onerous, but on the other hand, from the perspective of an individual who has taken a lot of their time to create the work, it makes a lot of sense. Therefore, our first step when somebody contacts us is to investigate the matter and to find out whether the individual actually did have a license. Sometimes we have discovered that our client licensed the image to an entity with the right to relicense. Therefore, even though the entity ended up relicensing it to somebody else, that individual may have intellectual property rights to use the image on their website. Most of the time, however, the individual has simply gone and used the image without a license, either intentionally or unintentionally. The Copyright Act provides two alternate remedies for an individual who seeks damages for copyright infringement in federal court. The first is called statutory damages. The second is actual damages. The plaintiff gets the right of election. They get to choose which measure of damages they want, assuming that they're successful in court. If the plaintiff chooses statutory damages, they could be awarded from $750 up to $30,000 per use for non-willful infringement. That's a lot of money, considering the fact that the individual may not have even been aware that the image was copyrighted. If the use and infringement was willful, the Copyright Act provides that statutory damages could be up to $150,000 per use. On the other hand, the plaintiff may elect actual damages. So, for example, if an individual did not have the rights to use an image, and they went and produced a commercial item like t-shirts or other promotional items and produced many thousands of them and sold them, the actual damages, meaning the amount of money that the individual actually profited or that the artist lost as a result of licensing fees that were not paid, may exceed the $150,000 statutory damage cap. As a result, individuals who have found that their works have been used in an unauthorized manner would be advised to contact a copyright infringement attorney so that we can pursue their rights. Just because somebody else has gone and ripped you off, that doesn't mean that nothing can be done about it. In many cases, we even take contingency matters on in our office, which means that you will not have to put any money down before hiring us to get involved in your case. This does vary, and we do evaluate potential clients on a case-by-case basis. But just because you don't have the funds to put down a significant retainer for an intellectual property attorney or a copyright attorney does not mean that we won't take your case. To the contrary, I urge you to give us a call so we can investigate the matter and advise you of your rights and what we may be able to do for you.